Write your names so that I will be reading them this way, and then you'll be, so your first name should be at the top of each box, last name at the bottom, etc. And this, of course, is the left side of the room as I'm looking at you guys. This is you guys, because it gets flipped around and things get confused. Okay, so send that around. Oh, start there.
All right, cool. Thank you, sir.
I don't need, you don't have to multitask. Okay, so that's all the administrative stuff for the morning, I think. I try to start each day as the semester goes along by asking if you have anything on your minds. Obviously, I'm not referring to specifically the cases we're going to actually cover, but things that might be related to criminal law, or maybe even just law in general, or just questions you have. So I will start that right now. Anything on your minds you would like to raise? Yes, ma'am.
I read an article and I only really scanned it, and I'm consciously incompetent on the subject, but it was talking about how the premise of our justice system was that each offender will receive a trial by the jury of their peers. And the article was saying, is this being undermined by the fact that most people kind of cut a deal instead of actually going to trial? So are we actually fulfilling that burden of proof requirement that a plaintiff would have, and are we actually giving people their rights by saying, okay, you can either go to trial and have this long, heavy, hard sentence, or you can cut a deal and not have it so hard?
Well, the first thing I want to say about that is it would be nice if you guys could take my criminal pro class next semester. This is the first time I've ever taught criminal procedure, so we'll see how that goes. But one of the things I am emphasizing in my preparation for that course is that what you see on paper in terms of how we talk about the criminal justice system and its operation is not what really happens. The practice of criminal law for defense lawyers, prosecutors, bears no resemblance to this idealized version that you see on Law and Order, or name your favorite criminal show on television, that there's always these trials. The overwhelming majority of cases end up in plea deals that avoid the need for a trial. And so that's, in terms of the reality, that article is quite right. The reality is that trials are rare, not unheard of. Sometimes there just is not a plea deal, and some prosecutors or prosecutors' offices are notorious for, or legendary, depending on your point of view, for maintaining policies that say we will not agree to plea deals unless the defendant agrees to accept the full sentence and agree to plead guilty to all charges as we have filed them. And that leads to more trials than you would find in other jurisdictions. Does that, now the question, the values question, whether that undermines some of the values of the criminal justice system, acknowledging that that's the reality, that is, plea deals are the reality, that's a question for you all to ponder as to what value is served and whether overall positive values are served by bringing cases to trial. We would need a lot more judges. We would have to have a lot more people be willing to serve on juries because we'd have an enormously higher number of trials. The expense would be a lot higher. I think one result would almost certainly be longer sentences because people would, one of the results of plea deals is people get shorter sentences so that people would be in prison longer. And that would be more expensive, and whether that would be just or not is a whole separate question. Certainly the idea that there are public values served by having juries pass on the question, decide the question of whether someone is guilty, has committed a crime, that voice of we the people, it's one of the ways we participate in our government, is as jurors. We don't think of it that way. We think that we vote and we opine on in terms of the electoral system, but as jurors is one way we participate in governing ourselves, and that is undermined if most of the cases don't actually go to trial where jurors have to make decisions. So there's some gains from a system in which plea bargains are the rule, and there are some losses. And we will, that's more a subject for criminal procedure, than it is for criminal law, but it is the reality of how criminal law is practiced in our country. So that is undeniable. Yeah.
To follow up with that, don't you think we could like streamline the system, like a criminal prosecution, if we stop like criminalizing petty drug offenses that seem to be like less of a threat to society or more of a lifestyle choice?
Now you're asking me to be a legislator. You know, what kind of criminal law should we have, and what should we criminalize? And part of the answer to that lies in whether we think making certain conduct criminal serves the purposes of our criminal justice system, as we outlined the other day, and that we're going to discuss more today. So those might not be the only ways we could approach that question, by means of saying, does it serve overall the purposes of retribution and deterrence and incapacitation to criminalize this offense? Do we think that in terms of the norms of society, that making X a crime serves our interests or does not serve our interests? We have to make that decision. I will certainly ask you throughout the semester, when we get to certain cases, should this be a crime? And if so, what should be the requirements of it? Maybe we would say that a certain conduct should be a crime, but only if certain other circumstances exist surrounding it, because that would serve the purposes of our system. So I think that the legislative questions are ones that are certainly not going to be on our agenda, at least from time to time. Did I duck that question? As to what I think, personally, I think we should have a lot fewer criminal laws. I think our system would be a lot better off if we had a lot fewer criminal laws and dealt with other social problems in other ways. But what I want you guys to focus on is, how can I defend that position if that's my view? If your view is, I think this should not be a crime, how can I articulate a defense for that is based on the principles of the criminal law?
What is that, criminal procedure class?
There are 2 criminal procedure classes we offer to all upper divisions, so you don't have to worry about it this year. One is constitutional issues. So that's like search and seizure, right to counsel, jury trial, all the constitutional requirements that are in the Bill of Rights that pertain to how the rights that criminal defendants have in the criminal justice system. So that's criminal procedure, constitutional issues. The other, and that's not what I'm teaching. The other one is constitutional issues, judicial process. And that's things like, well, how does it actually operate? What are the nuts and bolts? Arraignments, jury trials, plea negotiations, sentencing, persistent offender statutes. How does it actually work when you actually have to practice this on either side of the practice, criminal defense, criminal prosecution? How does the system actually work from arrest all the way through to appeal? So it's a systemic, and it doesn't matter what crimes we're talking about. We pay no attention in that class to the crimes that people might be prosecuted for, but only how the system works in dealing with the business of prosecution. Okay? All right. That leads us to Kansas against Hendricks. Okay? So who can tell me what did Kansas do that ultimately impacted Mr. Hendricks? And remind me, you are?
Ryan Ken.
Mr. Ken.
Yes. Okay, so in '94, Kansas enacts the Sexually Violent Predator Act, which outlines a procedure for the civil commitment of people based on mental abnormality.
So we have a civil commitment. That's what we went to today. Good. Civil commitment for someone shown to have a mental abnormality.
Right, which would be opposed to, what was it? Mental illness was what it took to commit someone civilly previously, I guess.
And I'm gonna just say SVP, sexually violent predator, okay? And what did the Kansas Supreme Court do with the challenge to this law brought by Mr. Hendricks?
They said that it violated due process.
And one thing you always want to do when you're briefing these cases is ask yourself or note, what did the lower court do? In this case, the Kansas Supreme Court is the lower court because it's the Kansas Supreme Court's decision that is on appeal to the U.S. Supreme Court. Right? So you want to ask yourself, what did the lower court do? And that will set you up to then make your to identify how did the ultimate court deciding the case you're reading, how did they rule in either affirming or reversing that lower court. So the Kansas Supreme Court says violates due process. And how did it violate due process again?
So, I guess due process is saying that required legislation be fair and reasonable in content.
And what about the sexually violent predator law that Kansas enacted violated that requirement?
Well, that you could commit someone based on a quote unquote mental abnormality.
And what should it have been?
A mental illness.
Right.
Yeah.
Because due process requires the state to show mental illness, not distinguishing from an abnormality. It's not the Kansas Supreme Court doesn't say they can't do this. They just can't do it based on this showing alone. You need more actual mental illness. What does the U.S. Supreme Court say about that particular holding? We're going to dispense with that really quickly.
Okay, they said that that's not the case. You can commit someone to a civil institution based on mental abnormality.
They said what again?
That you can, in fact, yeah.
Abnormality as a showing is sufficient. No violation of due process. Abnormality is sufficient. So that holding is fine, or that part of the statute is fine, okay? The U.S. Supreme Court says depriving somebody of liberty based on mental abnormality is a sufficient basis for a conclusion that a person, at least maybe, someone like Hendricks, unable to control his behavior and poses a danger to public health and safety. Okay, so who's Leroy Hendricks, Mr. Cannon?
Leroy Hendricks was a pedophile, a convicted,
Child molester, yeah.
sorry, Dimitri.
Oh, yeah, convicted child molester.
Yeah, convicted child molester, yeah.
Convicted child molester, and in fact has a long history of child molestation, right?
Right.
And what triggered him bringing this lawsuit and this ultimately getting to the Supreme Court?
Right, so he said that this, he appealed on, or fought, I don't know that's not the right term, but on double jeopardy and ex post.
When I ask what occasioned it, I mean, why was there any problem here? I mean, he's a convicted child molester. He's going to presumably be in jail for a really, really long time. Why don't we worry about civil commitment of Leroy Hendricks?
Right, well, he's about to get out, right?
He's about, there we go.
Okay.
Hendricks is a convicted child molester, but even people convicted of really serious crimes eventually serve their sentence. And what happens when they serve their sentence?
Get released.
They get released, right? And therein lies the issue. Hendricks is about to be released. And how does the state of Kansas apparently feel about this state of affairs that Leroy Hendricks is about to be released, knowing, at least believing, that he represents a serious threat to public safety as a sexually violent predator targeting children?
Right. So they're worried about it, obviously, and they're worried about that he wouldn't be found to necessarily have a mental illness because he.
And they don't have to show that. The Kansas legislature has made that abundantly clear, that they only have to show this, and the Supreme Court says, good enough for us.
Right.
So that's okay.
Okay.
So they bring this civil commitment proceeding. Now what happens at this civil commitment proceeding? What happens? We'll give Mr. Cannon a break and turn to
McKellar, Fields.
Ms. Fields.
I guess they're scared he's gonna read a opinion because in his testimony he showed that he had a problem, that he thinks about it, that it's hard for him not to do it.
Hendricks is his own worst enemy in some ways, isn't he? He says things that make it really easy for Kansas to prove its case. He says, I don't think I would ever be able to really control myself, or words to that effect.
Yeah.
If you were his attorney, what would be your reaction when you heard him say that?
You go down.
You're like, I need a drink, or I need another line of work, or I need new clients, or maybe all three. Right? This is one of those moments we can pause and note that sometimes clients say the darndest things, and you better get used to it because it can be very, very frustrating, right? And so, how did this whole thing work, Ms. Fields? How did this whole thing, in terms of this civil commitment proceeding, set up by this statute? We know that what the burden was for Kansas. How did it operate? Give me some sense of how it actually unfolded.
I don't know exactly how they got into the testimony and stuff like that. I'm kind of confused on that part.
Who decided whether Kansas had met its burden of showing that he had suffered a mental abnormality and was a dangerous sexually violent predator?
The lower court.
Well, the lower court, more specifically,
I'm sorry, could you rephrase the question?
who decided? Who decided? You are,
Ms. Cole.
I'm sorry? It's called
The jury.
a jury. Jury decides this. And when the judge in this civil commitment proceeding, Ms. Call, gave this case to the jury and said, decide if he has this mental abnormality and whether he's a sexually violent predator who can control himself, what did the judge say was the standard by which it had to decide whether he was a sexually violent predator? Beyond a reasonable doubt. And what's our abbreviation for beyond a reasonable doubt?
BRD.
I don't remember.
BRD, right? Beyond a reasonable doubt. We're going to see that again and again and again. What does that sound like?
Bird.
Sounds like trial.
When a jury decides the issue and is required to decide it beyond a reasonable doubt, what does that sound like? A criminal trial. Right? In civil cases, as you may have already heard in some of your other classes, the standard is a preponderance of the evidence. Right? This starts to seem awfully a lot like a criminal trial. And that leads us to our friend Hendricks. He had this due process issue, but it leads us to the key issue here. If they are, has he done anything new that would justify new punishment?
No.
No.
He's been in jail. He hasn't molested anyone. and he is now, or is about to, finish serving the sentence that society decided would be fit punishment. He has paid his debt to society, as the saying goes, right? And he's done nothing new. So if he is being subject to a new criminal trial, and if this confinement represents resulting punishment from the criminal finding, then what problem is suddenly on the table? In the red shirt you are?
John Shoemaker.
Mr. Shoemaker.
Double jeopardy.
Double jeopardy. Since he hasn't done anything new, then he must be being punished again for the same old offense, and that violates his constitutional rights. And that violates his constitutional rights. So, with that in mind, Mr. Shoemaker, what does the Supreme Court, in this opinion by Justice Thomas, say about whether this civil commitment system represents double punishment again for the same crime, at least in circumstances like Mr. Hendricks's? Next to Mr. Shoemaker, you are?
Pay flat, and it doesn't fulfill retribution or deterrence.
The answer is no, not punishment, because, at least the first answer is, it does not serve what Justice Thomas defines as either of the two primary purposes of punishment. And what were those again? He finds the two primary ones?
Retribution and deterrence.
Mhm.
Retribution. What's missing? When he identifies retribution and deterrence, he says, this system isn't serving either of those two. In the back?
Incapacitation.
Incapacitation is missing. Right? What else is missing? Rehabilitation. So one question we want to ask ourselves is, what about incapacitation? And what about rehabilitation? Okay?
With incapacitation, they talk about how these facilities, they don't restrict the people in the way that they would criminals in a jail. They're free to move around. They have some civil liberties.
Anyone want to respond to that?
Well, incapacitation, I thought, was the idea that you were keeping them away from society, but
And?
still, and keeping them from committing more crimes.
And
He would be incapacitated if he were kept in a mental institution.
I mean, it's really hard, and I think the court kind of concedes this point. It's really hard to argue that this system is not motivated, really, like a laser focus on incapacitation. The whole idea is, because somebody like Hendricks remains dangerous, has a mental condition that renders them unable to conform their behavior, society is not safe if they are released, we need to protect ourselves, and in his case, our children, from him. So incapacitation is kind of a whole ballgame with this civil commitment regime. Yeah.
Yeah, they say that the rationale behind that is that your literary interest is not absolute, that the state can prescribe ways of narrow circumstances to force civil commitment because he was not rehabilitated.
Right? And the question is this one of those circumstances? I think that's absolutely right. And then the question becomes, if the state has decided that you have served your sentence, can it now say, oh, well, you served your sentence, but we have not rehabilitated you, and maybe you're beyond rehabilitation, so we can impose indefinite detention and tack that on as a new condition of your circumstances in order to make us more safe. Okay? He says, Justice Thomas says, that it does not, it's not retributive because it does not affix culpability for prior criminal conduct.
Mm-hmm.
That's a neat trick. Why do I say that's a neat trick?
Because it kind of is and is not. Because he's being committed on the mental abnormality of the crime that caused the crime that he's already committed, but he didn't commit it again.
And it just says it does not affix culpability for prior criminal conduct. What's the whole premise? What's the whole premise of Hendrix's double jeopardy argument?
What do you mean, like, why is the because they have reason to believe that he'll commit the act.
That's not Hendrix's argument. What's the premise of Hendrix's argument?
That he's being penalized again for the crimes.
And therefore that I did not commit any new crime. Right? I did not commit any new crime, so they must be punishing me for the old crime. Notice what Justice Thomas flips that argument on Hendrix. He says, this isn't about retribution because they're not punishing you. Kansas isn't punishing you for any criminal conduct. And just Hendrix is arguing, well, that's the problem. That's the whole problem, is that there was no criminal conduct that they could be punishing me for, having retribution for, and that's why it must be for the old criminal conduct. So Justice Thomas sort of slides past, writing for the court, slides past the whole premise of Hendrix's argument. And notice that. I want you to sort of look for those sorts of, did that really answer the point? Because sometimes courts are very slippery, and judges will not really engage the argument. And when you are practicing law, you will be frustrated by this. You'll be like, but I argued this. And the court seemed to ignore it. Maybe because the court didn't have a particularly good answer. So it just gave its own reason.